Good afternoon, everyone. Happy Friday. Thank you all for joining us today for a webinar focused on COVID-19 and recent Canadian immigration developments. Today, we're joined by partner Ravi Jain and associate Neerja Saini. We'll save some time at the end of the webinar for your questions, so please feel free to type out your questions in the text box on your screen. You can also reach out to us by contacting info@gans.com or by contacting the email addresses provided on screen. Don't forget to follow us on social media and sign up to our alerts, where we provide the latest immigration updates and breaking news. And with that, I'll hand things over to our panelists.
Thank you, Stephen. So as the Canadian government is moving very quickly and every day to take new measures to limit the spread of COVID-19, there have been just countless changes to the regulations, the rules and policies, and often without any further notice. And we've been working very, very hard to keep up to date and keep our clients informed on these fast moving developments on a daily basis. And of course, this rapid fire news cycle must have left a lot of foreign nationals confused about how these changes are impacting them personally, not just the ones who are trying to enter Canada, but the aspiring Canadians who are inside Canada who are now uncertain about their status. So these changes can be categorized in two parts, first being the travel ban and the second being the changes to the general processing of immigration applications. So with the travel ban, the system by which the government is regulating the spread of COVID-19 through the Canadian ports of entry is based on the Immigration Refugee Act, of course, and also through the Quarantine Act and the Aeronautics Act. So the Quarantine Act allows the federal cabinet to make an order banning travel or imposing conditions on travel to people who have been in a foreign country with a communicable disease outbreak. And the Aeronautics Act governs civil aviation. So the cabinet can make interim orders regulating the screening of persons entering an aircraft or an airport. So along with these laws, there's, of course, the government also issues ministerial instructions and program delivery updates that instruct these officers on how to apply these laws and what the practical application of these laws look like. And for these, the changes are even more frequent. I think for orders in council, there've been about 6 or 7 with the under the Quarantine Act only, but under the Aeronautics Act, there have been probably 11 and more, and they're always changing these things. So as the laws change and as we realize how these laws are being applied practically at the borders, of course, a lot of issues come up, and a lot of our clients were just seeing that they were not being applied equally or evenly. And so Ravi, being the chair of the CBA, he's been just amazing in trying to get a clear sense of direction as to how these acts are supposed to be applied, what the law looks like, what the practical application looks like. So Ravi, do you want to go into a little bit about what the changes we've seen since?
Sure. No, and that's right. It's been a bit of a whirlwind for the last several weeks. The last order in council relating to the United States, for instance, just removed the 14-day requirement. So there was a requirement that if you were coming from the US, you had to be either in the US or Canada for the last 14 days. You know, a mix of the two, or purely in the US for 14 days. That's now gone. So it's now just a matter of if you're coming from the US or not. But otherwise, the same sort of test and criteria around optional and discretionary, exists. So the US, if you're coming from the US, you have certain exemptions. Like if you are coming to become a permanent resident, for instance, there's no restriction in terms of, if you were issued your papers to become a permanent resident after March 18, you can still come. Whereas if you're coming from other countries, if they were issued after March 18, you cannot. There's still
only issue. Sorry, the only issue if you're coming from, so for the orders in council, there's two. There's one that deals with foreign nationals coming in from US only, and one that deals with foreign nationals coming in from any other country besides the US. So with the US, it's just if everyone is okay basically, unless of course if you're coming in for a non-optional or optional or a discretionary purpose. So, but otherwise everyone is okay, unless of course you also exhibit symptoms of COVID-19. But for the foreign nationals coming in from outside the US, everyone is prohibited unless you fall into certain exemptions.
Right. So those include, I mean, if you're outside the United States and you have a spouse and kids or common law partner, you need a special consular letter if those kids, for instance, want to come in as visitors. Whereas if they're coming from the United States, you do not need that letter. So that hasn't changed. So that Ordering Council was updated somewhat, but nothing radical. So since our last webinars, I just want to bring everyone's attention to that. There's been some change around students. So the minister recently announced, and the minister's office reached out to me and said, we've decided to do this. We're going to allow students who have working in essential areas such as healthcare, critical infrastructure, anything that's protecting the food supply. Those students will be able to work more than 20 hours a week, but only those students. So that was a nice thing they've done, because I think those students will help, Canadian society, right? And also, if you're a recent graduate or about to graduate in certain critical fields and you want to work, in the nursing homes or whatever, where there's right now a crisis, it also helps Canadian society in that way. Also, students, this was previously announced, if you're doing an online course, you can do that online course outside of Canada, but 50% of it must be in Canada in order to qualify for the postgraduate open work permit. So a bit of flexibility on that too, that was earlier announced. The main thing I've been focusing on is the test, the essential test versus the optional non-discretionary test. So people have written in, they said, listen, I don't understand, is there, is family reunification optional or discretionary? Like, am I allowed to reunite, like a Canadian, let's say they normally live in Florida and they're snowbirds and they want to reunite in Canada, maybe one's Canadian, one is not, can they come in? There's been questions about, if a foreign worker is here, can he apply for his family members or her family members to rejoin under reunification? There have been questions about, is there a test above the normal requirements of the work permits? So what I'm starting to realize is that, I've been in pretty much daily communication with immigration and the Minister's Office of Public Safety, which is the Border Services Ministry, and also the Minister of Immigration and his office. And, it's very, very confusing, because I've asked them to double check and triple check that there is no test upon a test, and that, the rules as they've been publishing them, and all the guidance, program delivery instructions, Neerja mentioned, all the guidance, etc., is something we can rely on, because we're used to relying on it. And unfortunately, what I think is happening on the ground is not what is reflected in some of the guidance, and certainly not what's reflected, in my view, in the orders in council and the laws that have been passed. And what I mean by that is that people are being denied entry. You have spouses being denied entry. You have situations where the person's coming in, meeting the basic work permit criteria, and they're saying, well, it's not essential. You have situations where a foreign worker or a student is here and they want to bring their spouse on an open work permit, for instance, and that's clearly listed in the laws, saying that if you have a work permit, you can come, and they're saying, no, you can't come in. So this has led to a lot of confusion, and I think that since the Deputy Prime Minister said that foreign workers are able to come and it's business as usual, I've seen a few carve-outs. There have been a carve-out for working holiday people, and they've said, look, that's not going to be allowed going forward. If you don't have a job and you're just coming in here to experience Canada, that's more akin to tourism, and they've clearly said that recreation is not allowed, so I can understand that one. I've also understood, although this isn't published, that if you're, if there's snowbirds, if there's a couple that normally lives in Florida over the winter and one's Canadian, one's not, but they ordinarily live outside of Canada, then those people may not be allowed entry. We've had horrific stories of people who are, fathers trying to come into Canada because they want to witness the birth of their first child or their children. And we've heard stories of those people being denied. So I'm trying to get to the bottom of it. And I think we are all used to immigration relying on, being able to rely on immigration, giving the guidance to CBSA, the Border Services Agency, and the border agents relying on the guidance of immigration, because immigration pays the border agency to administer its immigration program. And what we're seeing for the first time really is that the border agents are relying on their internal guidance, which we've heard many reports that exist, but we don't have a copy. So I'm trying to get a copy through the minister's office and focusing my efforts on that. I was also happy
that these internal documents, they don't conform at all with what the law states and what the IRCC is relying on. It's completely different and it has a different test.
Yeah, I mean, that's the issue, is that there may be a test upon a test. Now, the program delivery instructions, which are it's sort of like the web pages of the immigration department. There were a few interesting errors. I noticed, I read through them and I compared them to the last version, and I've just read the ones that were just released. And I can tell you that I told them that there needs to be a carve out for the case I mentioned. For instance, those coming in from the United States who have their, are ready to become permanent residents. The March 18 cutoff doesn't apply to them, and yet that is still in the program delivery instructions. Now, I just told them that it had to be removed, and I'm going to remind them that they didn't remove it. So that's one thing. They are starting to talk about, foreign workers who are coming in to do the work and they meet the work permit criteria and are essential. So that is language that I just saw today for the first time in the guidance that is on the immigration web pages. So I'm going to ask them about that, because again, the Deputy Prime Minister just said if you're excuse me, if you're coming in and you're meeting the foreign worker criteria, you should be allowed in essentially. So I'll follow up on that, but that is something I'm definitely paying attention to. I was just going to talk about some of the other updates. So there's now, people may have heard that there were a lot of people coming in through Roxham Road. So a lot of people were able to come and make a refugee claim if they entered at an irregular border crossing. And then the Safe Third Country Agreement, which required Canada to return would-be refugees to the United States, that is an agreement that applies at our official border points, but not the unofficial one. So people were coming in the tens of thousands through Roxham Road, and what happened is with COVID-19, the government said we're going to shut that down now, and they came to an agreement with the United States to shut it down. Well, I recommended recently that there be a carve out because there was a carve out for those who had some ties to the U.S. in some manner. They were able to make the refugee claim, U.S. citizens and some others who'd been there for a long time. So what I recommended was that the exceptions that apply to the Safe Third Country Agreement, namely having some family here, etc., also apply as a carve out, and they actually adopted that, and I was very happy to see that. In terms of those who are looking to become permanent residents and they're just waiting for the confirmation of permanent residence document, typically they would be called in for an interview and then they would be officially landed as an immigrant. They'd become an official immigrant. There's a new process now if you're in Canada, and they've done it for about 300 people already, and that is that instead of a telephone landing, it's an email landing. So you get an email and then they say, listen, you're now officially a permanent resident, and you'll get the official document in the mail, but you can use what we've sent you by email and that number to apply for your social insurance company. There also were some questions I noticed about express entry. One person wanted to know, I think, if there's going to be more draws. There were a couple of draws in 1 week. The last 2 draws were 1 week apart because in April, the draw was a week late. So I think the government told me and others that they are going to probably stick to every 2 weeks now. They will keep doing draws. They were not sure about that, but they advised me that they will keep doing draws, which is great. In terms of federal skilled worker, the draws are, it can be provincial nominee program, it can be federal skilled trades, it could be federal skilled worker, it could be Canada Experience Class. And lately it's been a lot of Canada Experience Class, and that's been deliberate because people are here, they don't have the same kind of issues with them because they're, they're already maybe self-isolating, etc. But I did point out to them, based on some feedback I got from a colleague, that the points for federal skilled workers are going to go through the roof when they finally open that up, because they've drawn down the group of Canada Experience Class people so heavily that when they finally open it up, it's going to be completely lopsided in terms of the the high numbers of points that those folks are going to need, because they haven't been taking any. And you were missing out on very educated, highly literate folks. So I pointed that out to them, but we'll see. They're just aware of it. They also indicated that, if you're coming in not on a work permit based on an LMIA, a labor market impact assessment, but on a different type of work permit, there was a question about whether you could work from home, because sometimes the work permits, the closed work permits that name a specific employer also have a location. And if you're working from home, you're not working at that location. They've indicated that that in all likelihood that would be waived, and they would not consider that to be non-compliance. So people should be okay with that. There's also, people should know that there's a fee increase as of April 30th that's scheduled, an application fee increase. If your application's already in the mail, you should be okay. But I also want to advise people that I suspect that they'll delay that fee increase, because that was planned well before COVID. People should also know finally that if you're flying in, face coverings are now mandatory. So there's been some new guidance on that, and people should be aware that when you're flying in, you should cover up. So I'll deal with a couple questions, and then I'll let Neerja screen as I'm doing that for the live questions, and then I can handle some live questions too if she gets through a first couple. But people were asking about working holiday extensions. Listen, I would say if you have a working holiday work permit, you're lucky, because they're not letting people in with working holiday work permits right now, because again, they see that as more akin to recreational type of activity. So in terms of extensions, I would say start thinking about, if your employer really likes you and there's a shortage of Canadians that can do what you can do, think about a labor market impact assessment and get out of the working holiday category. Or maybe they'll allow for young professionals if you can switch from, from working holiday to young professional, which is all considered under the umbrella of an International Experience Canada category. I did ask about young professionals. They didn't answer me on that yet. I think they're still thinking about that. If your bridging work permit was denied, but you're in an essential job, can you restore? Well, I mean, a bridging open work permit, if it's denied, I don't know why it would be denied. Like normally, if you apply within 4 months of it expiring, it should be approved. If it's denied because your permanent resident application was denied or something like that, then it's not really possible to restore, because you're not really bridging for anything anymore. But you may be able to restore if you are doing work that is absolutely critical, in the healthcare field or food supply or something, and potentially an argument could be made. So you'd have to contact us for that one. It's very, that would be a very technical argument. In terms of layoffs and PNPs, I mean, we're also getting questions around layoffs and Canada Experience Class, and there's no word on that yet. Different provinces are being have different approaches in terms of flexibility, but nothing official on that from IRCC. They're thinking about it. Error when applying for express entry. If you made a mistake when you did your profile, yes, the question was, should I decline? And the answer is yes, you should decline. I think you should contact us too. A lot of people have a false sense of security with respect to express entry, and we see very bright people, physicians, lawyers, professors who fill out their profile, and we used to take cases based on the work that they had done, but lately I I prefer to decline and or just scrap their profile and redo it, because I'm seeing a lot of mistakes, and there's very serious provisions for misrepresentation because you've taken a spot from someone else and barring you for 5 years. So I would say it's better for us to do it and make sure it's done properly. Another question, can you apply without police clearances and medicals? Yes, you can. Any delays due to COVID-19 will not be held against you. Are there processing delays for express entry? Well, I would say maybe yes, maybe no. On the one hand, they have less applications coming in, so there's more capacity. On the other hand, they're working from home and they're slower. So they do need to still do biometrics, and so we have to wait on that. But I would say let's wait and see. I don't necessarily foresee massive delays in that area. CRS scores, people are asking if they're going to decline. Again, I think that if they continue to focus on a Canada Experience class and you are a Canada Experience class person, then we might see a decline, but I would expect that they may start to focus on some other categories. And lastly, visitors. If you're here and you have a student approval letter, the question was, can I start to study? And the answer is no. You have to actually get the study permit to study. And so right now there's no provision to be able to switch from within the country. And of course, you're not allowed to go to the border to flagpole, which means going to the border and then turning around and coming back into Canada right away and saying, please issue my study permit. That's not allowed right now. So I'll turn it over to Neerja, and she can tackle any of the questions that have come in, and I'll read some of the bottom ones as you do that.
So someone's asking if you can apply for a spousal open work permit based on the spouse being a full-time worker. So that depends on if you're inside the country or outside. I mean, if you're inside and you apply, it will have to be an online only application. And for that, if you need biometrics, you might be waiting for a while because all the biometric facilities are closed. So you can submit an application. If you're extending your status, you'll have implied status, but you won't necessarily be able to work. But if you're coming in from outside of Canada, then yes, you can. As long as you get the work permit approval letter, then you can come in at the airport and do your biometrics at the airport. So, and as Ravi said, flag polling is not allowed. So if you're inside, it will have to be an online only application. And again, yes, you can submit your police clearance and medicals after. And I think quite a few of the express entries, so they have a deadline, and I think some of our clients had already noticed that there's an automatic extension of time to submit that too. But even then, of course, in some countries, it's just a reality. Some these medical offices won't be opening for quite some time, so you can definitely submit your applications without that. And how long will it take to process inland spousal sponsorship? That really depends. There is an online tracker that sort of tells you what the average time is, but of course that changes all the time depending on how many applications they are looking at. Okay, I think that's what I can
say. It's hard to read quickly and answer. So let me jump in. There are some questions around how do I activate my permanent residence if I cannot flagpole. And as I said, there's a new process of landing people by email. So the government will just email you and say, oh, you're landed. So that's the new process. They're starting to roll it out. And I think the same person asked, when do you apply for a bridging work permit? And the person has 6 months left on their work permit. Well, again, you have to apply within 4 months. So you can't apply earlier than that. So yeah, I think unless you want to tackle any more questions, Neerja?
I think that's what I see.
Yeah, I think a lot of the questions we actually already answered. I noticed a lot of them were about, can I still apply even if I'm waiting for certain things like medicals and police clearances. I'm seeing a lot of those questions. Another one just came up again. So I'll just answer again that it won't be considered incomplete if you can't do your medical and your police clearance, and we can help you with that. I mean, you know, there's guidance we can cite to the department so that they don't make any mistakes on that. And lastly,
And
you know,
sorry, on that one, if you already have an application in process and they request biometrics or medicals on any application that was already in process before these new measures came in, then there is automatically an extension of 90 days on those document requests, and that's on the IRCC's website.
Yeah, and I expect they'll probably extend again if there's if we're still in the same sort of situation. So if you have questions and you want to have a consultation or you want to clarify things, I'll give you my email. It's ravij@gans.com. So it's ravij@gands.com. Neerjas is neerjas @gands.com. So you can email us. That's the best way to reach us. If you're looking for a consultation with one of us specifically, you can email us directly, and then we'll take care of booking you in. But I hope that answers all of your questions, and have a great day.
Thank you.